Okay, let's go ahead and set forth our appearances.
Yes, Your Honor.
Kemp for plaintiffs.
My apologies, go ahead.
Mr. Kemp.
Good morning, Your Honor. Spencer Kook on behalf of the Liberty defendants, which comprise of Ohio Security Insurance, Ohio Casualty, Peerless Indemnity, and West American.
And have the plaintiffs set forth their appearances? I don't think so.
Mr. Kemp, can you repeat your appearance, please?
Your Honor, Will Kemp for plaintiffs.
Thank you, sir.
And Teddy Parker on behalf of the plaintiffs, Your Honor.
All right. We have Miss Switzer. She must be just observing.
Yeah, she's just observing.
All right. Anyway, we have a couple of issues before we get started. It's my understanding we have the special motion by third-party defendants, Ohio Security Insurance Company, Ohio Casualty Insurance Company, Peerless Indemnity, and West American Insurance Companies to dismiss the plaintiff's second amended complaint and request for reasonable costs and attorney's fees, right?
That is correct, Your Honor.
Okay.
Well, Your Honor, actually, you at the last hearing we had on the October 23rd, I believe it was, you extended our time to file an opposition for 5 days until after you entered the ruling on the motion to strike. And there's been no ruling on the motion to strike, so we haven't filed an opposition brief to this. They haven't filed a reply because there's no opposition, so the matter's not fully briefed.
Right, I understand. I do. And here's my question, and I thought about this, and I don't mind telling you, as far as the motion to strike is concerned, I've reviewed all of its points and authorities in a little bit more detail. And I could handle this one of two ways. I could deal specifically with issuing a scheduling order, not a scheduling order, but a minute order, versus just ruling from the bench today. Because I had an opportunity to look at a lot of the different issues as far as this case is concerned. And I have some comments as far as some of the case law.
Would your order encompass also issuing an order on the motion to sever? And as you may recall,
We don't have that, I haven't looked at that in great detail. To me, the pertinent issue that's really controlling as far as my ultimate decision is concerned in this case is specifically what to do with the motion to strike. And I took a look at the procedural history of this case in some detail, and I'm just referring to my notes. For example, the second amended complaint was filed on 11/12/23. I understand there was a removal of the bankruptcy court on November 14th of 2023. I understand the motion remand came down. And I think at the end of the day, ultimately, what I have to do, I have to make a determination as it relates to Nevada anti-SLAPP, the Nevada anti-SLAPP motion pursuant to, I think that's section 41.660. Is that correct? And the other, and one other provision.
yes, it's 41.660.
Right. Ren too. Any questions on that?
Well, the reason I raised the motion to sever, Your Honor, is, and again, I respect the fact that you're still cogitating over it, but as you may recall, the remedy we requested is if you were to grant the motion to sever, the action against Liberty and the claims should be set forth in a new action, new case number to a randomly assigned judge. And if you were to grant that motion and that relief, then it would make sense that the new presiding judge, whoever that might be, it may still be you, the random assignment comes to you, Your Honor, would be the person that actually decides the anti-SLAPP motion. And that's why I posit that, Your Honor, as to why, whether or not you'd be addressing that issue first or not.
Yeah, Judge, I don't think that's the way it works procedurally. Even if you were to grant the motion to sever, you'd still remain the judge. I don't know why counsel thinks it gets reassigned.
I've never seen that, Mr. Kemp, to be candid with you.
Yeah,
Well, Your Honor, if the case is not reassigned, Your Honor, then what you were doing is allowing Mr. Kemp to take advantage of his Rule 14 violation. Rule 14 only allowed Mr. Kemp and the third-party plaintiffs to bring in liberty in this action as a third-party defendant if a claim was asserted against the third-party defendants for which liberty is liable. There was no dispute at the last hearing, and there was no dispute, Your Honor, in the papers.
Was filed on the 17th.
Go ahead, sir.
There was no dispute, there was no claims against the third-party plaintiffs. So the third-party defendants could not have properly brought liberty into this case. They needed to have brought liberty into a completely new action, for which then they could have had their peremptory rights, strike rights. There would have been complete diversity, for which they could have then removed the case. They would have had the protections of the matter rules of civil procedure, which allow for a discovery stay, which allow for case management. None of that has happened because liberty was improperly brought into this case. So, Your Honor, if you were to agree that it's a Rule 14 violation, and I think it is without dispute, there are two proper remedies. The first remedy being you sever it into a completely new action and treat it as if it was a completely with a new case number, which you have the plenary ability to do so, or you dismiss the case and have Mr. Kemp refile it as a new action, which he should have done. You can't just keep the case. Otherwise, Your Honor, then he will have taken the benefit of the form shopping he intended to do by having this case brought into this case.
Right. And then
Your Honor, first of all, the motion to sever is fully briefed. I'll submit it on the briefs, you know.
oh, yeah, I mean, I'm not gonna re-argue, Mr. Kemp, because I'm looking at the timeline. Your motion to strike was filed on 10/14, is that correct?
Yes, Your Honor.
The motion to sever was filed before.
It's a motion to sever filed.
Yeah, but Your Honor, the problem with his basically he doesn't want just a severance. He wants you to recuse yourself, transfer to another department. And now he says he wants the whole case dismissed, and under what grounds, I have no idea. And to be required to be refiled, you know. If he wants those things, he should file a motion asking for those things.
I agree with that. I'm just looking at this from a what's that file?
On October 9th.
Okay. All right. So as far as today's concerned, and specifically limiting myself to the current procedural posture, there's no opposition filed, so we can't hear this until I make a determination on the severance motion, number one, and number two, the motion to strike. Is that correct?
I don't disagree with that, Your Honor.
Yeah,
That makes sense.
Well, Your Honor, I think you need to hear the motion to strike because that's related to the issue of whether we file an opposition. The severance, I'm not arguing you shouldn't consider it at some point, but I don't think that's a prerequisite to hearing the motion to strike. It's counsel suggests.
Right.
Except that it was filed first, Your Honor. It was set in time prior, and Your Honor, again, if you do not provide the remedies we requested, you are condoning the Rule 14 violation. There must be a remedy for it. And Your Honor, this court has the ability to sever this case into a completely new action, have it randomly assigned, Your Honor. There's nothing that says you can't do that.
Well, Your Honor, first of all, there is no Rule 14 violation. The third-party complaint was properly filed. And I point out they didn't say one word about this for a year in bankruptcy court about it being improperly filed. And second of all, like I've already said, he hasn't filed a motion to disqualify. He hasn't filed a motion to dismiss. If the severance motion should be considered on its own merits at the appropriate time. And I just ask that we get the ruling on the motion to strike so we can at least get that behind us.
Just to correct some misstatements, Your Honor. in the bankruptcy court, we did raise fraudulent misjoinder. I'm not sure why Mr. Kemp has said that again in open court when I've corrected him the last time we were here. We did raise this issue in bankruptcy court. It's not an issue that was belatedly raised, Your Honor. So with that, Your Honor, I understand. I think you are going to punt this down the road.
Well, what I'm gonna do is this, number one, and I'll just enter I've reviewed everything I need to do as far as the motion strike's concerned, but just as important too, I'm gonna pull the severance motion. I'm gonna enter minute orders on both of them, and we'll have them done very quickly.
Appreciate that, Your Honor. Did you also, as a matter of scheduling, want to prophylactically set a date for a hearing on the special motion to dismiss, or will that just be?
No, you know what? Maybe we can do that, say 3 weeks from today. How's that?
I have no problem with that, Your Honor.
And that's a good idea, sir. Check your calendar.
Thank you, Your Honor. Which specific date are we proposing, Your Honor? Is it exactly 3 weeks?
Yeah. How about December 4th at 9:30?
I do have a conflict from December 3rd through the 8th.
Okay, the next week. December 11th at 9:30.
That works for my schedule, Your Honor.
All right.
I'm agreeable to that, Your Honor.
Okay, Mr. Parker, is that good for you too, sir?
Yeah, I believe you said what day, Your Honor?
December 11th at 9:30.
December 11th at 9:30. Hold on one second, Your Honor. Yeah, that works for me, Your Honor. Thank you.
That's when it'll be. Is that fine for you, sir?
Yes, Your Honor.
Thank you. And we'll come back for that. And the minute orders will be published well before then.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.